to have the privilege of sharing a classroom with you. Let me start by bringing to your attention. What you're actually doing and when you're actually arguing. By the time oral advocacy in a final hearing appears, when it's right, at that point in time, the tribunal has had all the arguments, as you know, briefed for a long period of time. The tribunal has the memorials, the counter memorials, the replies, the rejoinders, everything. Moreover, the tribunal also has all the evidence, all the exhibits, and all of the witness statements. Okay? So then the question and the mindset that you have to have is the following. What then is oral advocacy? What is the purpose of what I'm going to do if they have the tribunal, meaning they have everything in writing, and they've had everything in writing, and I am extremely limited in the extent to which I may deviate from such writings. I am extremely limited to the extent to which I may present new evidence. So how can I be most effective rather than just being redundant? That's the question. I will give you my answer, not the answer, because I don't believe there is an answer. I will give you my answer to that question. The answer to that question is persuasion. You are there to persuade. You are there to contribute what the written word cannot contribute. Okay? And you're there to do this with rules that favor you a great deal. Now, let me tell you what I mean by rules that favor you a great deal. Regrettably, most of us say, oh, wow, I am now going to engage in the oral pleading or in the pleading of the case. But how many of us have gone to the dictionary to understand what pleading really means? Ladies and gentlemen, pleading means argument. And why do I say argument is somehow special? Let me contextualize it for you, and then we're going to get into the nuts and bolts of our discussion. In most common law jurisdictions, in court, in the final hearing, so to speak, in what they call trial, as you know, there's something called an opening statement, where the lawyers get up and they present their case. And that open statement has many rules that limit the lawyers. The lawyers cannot comment on the weight of the evidence. The lawyers cannot comment on the law that applies. The lawyers cannot comment on the application of law to fact. And the lawyers cannot comment on the credibility of evidence or of witnesses, another type of evidence, of the witness statements, let's say, in the case of arbitration. They cannot do any of these things. And that's why in common law jurisdictions, when you engage in that oral pleading that they call opening statements, you're very limited. In international arbitration, ladies and gentlemen, you are not limited. Listen to me. In international arbitration, as the party pleading, making an opening statement, you're not making an opening statement, you're making an opening argument. You can argue. You can argue the sufficiency of the evidence. You can argue the legitimacy of the evidence. You can argue the extent to which evidence is probative, the extent to which evidence is qualitatively proving a proposition. You can argue that. You can argue why oral presentations in the form of witnesses and witness statements are persuasive and why they are not. You can comment on the law, you can comment on the facts, you can comment on the application of law to facts, and you can criticize, you can be critical of the other side's presentation a prioristically before they present. This is what I mean by argument. It's a lawyer's dream to plead orally, because at that point, you become lawyer, client, witness, expert witness, legal scholar. You will never have that opportunity in the arbitration again or ever. Again or ever. So your mindset has to be, I am going to go there, and what am I going to do? I'm going to argue my case. What does that mean for purposes of this particular lecture? It means I am going to prove my case. I am going to prove my case. Now, let's step back for 1 second. In the final hearing, when you are at that hearing and you're making the arguments, there are 4 important things that the tribunal will be considering, mostly from an evidentiary perspective. The first of these things is admissibility. Is the evidence going to be admissible? So that means that when you're going to start thinking about your opening argument, you're going to think about admissibility. You're going to explain to the tribunal why it is that the evidence in your case is admissible. And the second thing, so you're going to think about your evidence. You're going to think about admissibility and the way what you're presenting and what you're presenting. And to the tribunal, you're going to remind at certain junctures, you're going to remind the tribunal that this is admissible evidence. And then you're going to look at 2 other things in connection with that admissible evidence. And you're going to remind the tribunal of these 2 other things: relevance and material. Relevance and materiality. So already we have admissibility, relevance, and materiality, those 3. Let's stop for a second. Why are these 3 considerations important in the oral argument? One reason. In our field of international arbitration, we only have one standard. We only have one standard for evidentiary assessment, and that's relevant to the case and determinative of the outcome, material to the outcome. Is something relevant to the case and material to the outcome? If it is, then that evidence is extremely important. That means that when you're arguing, you want to show the tribunal that your evidence, your arguments are relevant arguments and material arguments. Now, here's the problem. The problem is that in our field, in academia and in practice, we throw around words like relevance and materiality, and then we pretend we know what they mean. The IBA rules on the taking of evidence on international arbitration mention this standard 9 times, but those rules nowhere define relevance and nowhere define materiality. In fact, they don't even define evidence. The definitional portion of the rules is only operational. They'll tell you what an adverse party is. They'll define a tribunal. They'll define a hearing, but they won't define the standard for the taking of evidence and the consideration of evidence. So when you're trying to put together your oral pleading, your opening argument, as I call it, argument, when you're trying to put that thing together, you're going to think in terms of admissibility, relevance, and materiality. And I want you to think of relevance in this way. Evidence is relevant if it has a tendency, more or less, to prove a particular fact, where if you didn't have that evidence, the tendency, more or less, to prove that fact would not be there. So evident relevance is something that has a probability and tendency of proving a fact. Now, that fact has to be an important fact. What is an important fact? That's where materiality comes in. Materiality means that the fact is of consequence or of potential consequence in determining an issue in the case. In determining an issue of the case that is outcome determinative. Stop for a second. So now you're going to start structuring your argument by saying, okay, I want to, and we're going to get into many specifics in just a little bit, but I need to give you a framework that is often ignored. And if you do not ignore this framework, if you take it into consideration and you argue relevance and materiality, as I am explaining it to you, to the tribunal, I don't know about the Vis tribunal, but I'm talking about a real tribunal. So therefore, to some extent, probably to this tribunal. If you talk to them about relevance, why this is so relevant, why is the testimony of Mrs. X so relevant? Why is the testimony of Mr. Y so relevant? Well, it's relevant because it is more likely to prove fact delta than proving fact delta would be without that evidence. And when you explain this to a tribunal during the course of your advocacy, ladies and gentlemen, it is extremely powerful. Now, the second part of this is, what is fact delta that the evidence is trying to prove? It's a material fact. And why is it material? Because it can be of consequence to the determination of the case. So in making your arguments, you will talk about why this fact delta that the evidence tends to prove or establishes actually is extremely important and relevant and front and center to a tribunal's consideration. Stop for a second. There is a major conceptual difference between just rattling out, stating facts and saying that it is important and explaining why facts are relevant and material. Do you understand that? Do you see that? It's important. Now stop for a second. I want to tell you one more thing. I want you always to remember admissibility, relevance, and materiality, but there's a fourth component that I have perniciously, because I'm not a nice guy, I left it out on purpose, which is weight. Admissibility, relevance, materiality, and weight. The weight of the evidence. That's what the tribunal is concerned with. That is what the tribunal needs to process and to fill in the gaps. Now, what is weight? Weight is what you are going to do. Weight equals, if I had a blackboard here and I don't, weight equals persuasion. While you can define relevance and you can define materiality, the weight that a tribunal is going to give to the evidence cannot be defined and can only be explained through persuasion. You understand that? Persuasion. So that means that
Pedro, apologies for interrupting. There is a question from the audience. Maria Sole, please.
Yes, sorry, I was just wondering, are you suggesting that if we prove materiality and relevance of any kind of evidence, that could be as important as a more formal evidence? Let's say that we have a piece of a newspaper, of a journal. Can we still prove that that piece of journal is still so important, so essential to the case that the tribunal actually take it into consideration?
Excellent question. Yes is the answer. Yes, and here's why. Here's why. If I show, let's assume that there's a journal that reported it, right? Reported fact X. And you're saying, well, it's just this little journal, it's just fact X. I'm going to say, in fact, a third party having absolutely no stake in this arbitration reported fact X. And I am here to share with the tribunal this fact, this proposition. This is a disinterested third non-party. This is not a stakeholder. And now you see how what I'm doing now I'm trying to persuade. Now, if I'm on the other side and say, let me explain something. I'm sorry, what is your last name? I can't read from here. I'm going blind. What is your last name? The lady who posed the question, the student.
Yes.
Maria
My
Sola?
last name?
Yes, Maria.
Maria.
So what the other side of that question, the other side of that argument is counsel for claimant, when it's my turn, counsel for claimant stood here before this tribunal and argued the importance of a newspaper article. And she said that that article was both relevant material and therefore potentially dispositive to the outcome of this case. And moreover, counsel said that that article was written by a neutral stakeholder who had nothing to do with the case, and therefore there's credibility. Now, let me say a couple of things about that. First of all, counsel did not explain why that was a neutral stakeholder. For all we know, and for the data that's before this tribunal, the author of that article is partisan, and cannot be relied upon. Second of all, the article doesn't itself explain the foundational factual bases for the conclusions. The article explains the what, but the article does not explain the how. And therefore, this tribunal should accord zero weight, no weight to that article. And quite frankly, I am surprised that given that there's a limitation in time to make arguments that are important in the case, probative in the case, relevant material, such a thing would even be raised. Now, let me move on to my next point, which I think the tribunal may find helpful. You see it? So those are, I gave you both sides of it, using just the rubric of admissibility, relevance, and materiality and weight. So weight is what we are trying to fit in. Weight is what we're trying to accord to the evidence. So now I'm going to say one more thing, and then we're going to start on principles that I want you to consider. Again, these are just principles that I want you to consider. When you're making these arguments, the first thing that I want you to do is I want you to be yourself in making the arguments. And I want you to know this principle. I want you to be who you are. I want you to be legitimate. I want you to be your own person. 30-second story. I've seen many lawyers. I go against many lawyers. I'm not going to mention names. The best oral presenter in international arbitration, the best whom I have ever seen, and I've seen virtually everyone who's anyone, has a speech impediment. She or he, I'm not going to say, because that person's still in practice, has an impediment. I've seen that person because I've lost 3 cases to that person, billions of dollars to that person. So I know that that person is very good. And one of the reasons why that person is a first-rate oralist is because that person comes across as extremely genuine and credible. And that's what you want to be. You want to be yourself. You want to be genuine and credible. Now, here's something that I want you to keep in mind, please. The idea of arguing the case, of proving your case, I want you to think about pleading orally as proving your case, okay? Explaining, as I did, both sides. Well, I mean, whichever side you're on, but talking to the tribunal like that. And let me explain to this tribunal why this proposition, this factual proposition, is so important, and the reasons why it is outcome or potentially outcome determinative. There are 2 grounds, and then you go forward. You talk to the tribunal, you explain things to the tribunal within being yourself. The first thing I want you to know, additional thing I want you to know, additional proposition is the following. When you start and you introduce yourself, hi, I'm Maria Sol Cali, counsel for a claimant, General Energetics Incorporated. I want you to say something about your client. I want you to explain what your client does. And I want you to explain what your client does in more than just a money-making way. You understand? In more than just, my client is the largest energy plant construction company in the world. I want you to say more. My client, General Energetics, is one of the largest fossil fuels manufacturer of plants in the world. That's what my client does. And I want to share it with the tribunal that, of course, my client does this. General Energetics, you stop talking about my client. You stop personalizing, you remove yourself out. General Energetics builds power plants all over the world. And in doing so, it creates micro and macroeconomic benefits. It tends to create jobs, opportunity. It instructs local populations on technical matters, provides education, not just job and security, but provides verticality and opportunity in the communities which it serves. And moreover, even though economists argue about all things, there is one thing about which economists all are in agreement, and that is that foreign direct investment is the simplest way of creating wealth. So my company, so General Energetics, a company that builds fossil fuel plants throughout the world, also is a creator of jobs, opportunities, and wealth for countries in the form of foreign direct investment. Now, let me tell you what this case is about. You understand? You humanize your client without falling into the extreme pathological silliness of making your client appear to be, well, shall we say, Mother Teresa. No, not that extreme, but you're going to show how your client is of consequence in the world and not just a profit and loss. So you introduce your client, and I want you to think about that. I want you to think about that. Second thing, I want you to, ladies and gentlemen, please develop a theme. Okay, develop a theme. This case is about a situation where a foreign investor invested, and after making that investment and being seduced and lured into making the investment, the relative positions of power changed and the host state misappropriated the investment. This is about a sovereign state using its powers illegally to own an investment rather than to live by a shareholder agreement. Okay? Or you can say something very different. This, if you're the state, this case is about a foreign investor coming into the country and then abusing local rights, abusing domestic law, and engaging in self-profit to the detriment of the host state's ecological law and better interests.
Pedro, apologies again. Pedro, apologies again. There is one question from Manuel, please.
Good afternoon, Mr. Pedro. My name is Manuel. So to briefly introduce my question, since the problem of the Vis Moot of this year represents a disputed issue regarding a disclosure of the third-party funding agreement, my question is, in your career, did you ever engage in a case where a court has considered as material the disclosure of a third-party funding agreement, material to the outcome of that specific case?
Yes. Yes, of course. Of course, it can be anything. It can be very material. But you have to prove the materiality and the relevance. First, you have to show the relevance. You have to show the relevance. And then you have to prove the materiality. Let me tell you what I mean by that. Let's make it simple, okay? Let's assume that at issue is, well, let's use the non-disclosure agreement. At issue is whether there has been a disclosure under the non-disclosure agreement. And secondly, if that disclosure waives the protection of the agreement. Now, let's assume that the fact that you want to show that is relevant is the length of the agreement. It's a very lengthy agreement. That's relevant. because at issue is the agreement itself. So the number of pages of the agreement, of course, it's relevant. It tends to prove what the agreement is physically. Is it material? Of course not. The length of the contract doesn't tell you the content of the contract, the terms of the contract, their applicability, the limits of that protection. You understand? So that's, first of all, the relevant part, but here's the part that's important. I don't know the facts of the fact pattern here, but here's what's important. When you're talking about materiality, you have to show that the fact that the evidence shows as being material, outcome dispositive, potentially outcome dispositive, material to the outcome, you have to show that that fact is material. So whatever the non-disclosure agreement was not disclosing, that fact that is being protected by the NDA, that fact has to be consequential. So you would attack that fact and you say, that fact is not material. It cannot be consequential for these 15 reasons. First, and then you start going. And then you may even have an argument that says, but even if it were material, even if it were potentially dispositive of the case, no damages would flow from the incorporation or consideration of that fact. The claimant cannot show how the actual purported alleged disclosure caused quantifiable harm. These are, see, so you're saying, big deal. What was protected and allegedly disclosed, allegedly wrongfully disclosed, cannot change the realities of whether the claimant really suffered damages. And the claimant has the opposite approach. Okay? May I continue?
Thank you, Mr. Pedro.
Yes, okay, good. So I want you to develop a theme. Now, let me tell you something very quickly about developing a theme. When you say, this case is about broken promises. This case is about not adhering to contractual language. This case is about betraying the sanctity of a contract. This case is about the careless betrayal of confidential information. This case, okay, just as you do that, I want you don't just say the theme and forget about it, okay? I want you to repeat the theme throughout your presentation, ladies and gentlemen. I want the tribunal, when you sit down, I want you to be able to say to yourself, if the tribunal believes even 50% of what I said, why I said it, and how I said it, I win. Okay, so you develop a theme, you repeat that theme. I want you to early on, develop a roadmap. What does that mean? It says my presentation today will be divided into 4 parts. The first part will establish, will show, will demonstrate. You understand? Not will argue, will purport to, forget about that. Will demonstrate, will establish X. The second part will establish or demonstrate Y. The third part proves that X plus Y equals Z. And the final part that I'll bring before this tribunal's attention are the damages, D plus E equals X. And then you start with your formal presentation. Let's stop there for a second. An opening argument, when you start with those formal presentations, listen to me for a second, okay? I want you to start with something that's called primacy, P-R-I-M-A-C-Y, primacy, a strong argument. You are going to have your arguments based on their strength, not chronological order. we're going to use conceptual order. And why not chronological order? You have to be careful with chronological order. First of all, because the tribunal knows the chronological order, ladies and gentlemen. Remember, they have the memorials, the counter memorials, the reply and the rejoinder, and all the witness statements. They know that. You don't have to. But we're the way we're raised as children is once upon a time, and we're raised in chronological order, not in conceptual order. But you're winners. You're going to win because you're going to have conceptual order and primacy. You're going to start and say this arbitration is about the mismanagement of the sanctity of a contract. And I will establish through the three referenced parts of this presentation why that is the case. And you start with your strongest argument. Okay? Now, when you start, listen to me. I want you, these are called eyes. And you know why we have eyes here instead of here? I'll tell you why, according to Darwin, because we are predators. We are predators. That's why our eyes are here. And I want you to look at the tribunal's eyes. I want you to look at the tribunal in their eyes and talk to them and persuade them and connect with them. Yeah, just like you look at your boyfriend or your girlfriend's eyes, you understand what I'm saying. I want you to look at the tribunal's eyes, and I want them to look into your eyes. And I want you to believe in what you're saying and how you're saying it. So now we're going to start conceptually with our best argument. We're going to be developing a theme. We're going to have our presentation broken down, and we're going to follow that presentation, that order. Now stop for a second. Look, after you finish part one, you're going to have headers. What is a header? You're going to say, now with the tribunal's permission, I will present to the tribunal the second part of the presentation, which concerns or addresses X. So now you've said, okay, I finished with that. Now let me guide you to the second part of the roadmap. And then you're going to do this all throughout. Again, in the second part of the roadmap, I want you to start again with your theme. You repeat your theme over and over. Remember, your position is when I sit down, I don't even have to call a witness. I won this thing. I proved my case. I proved relevance, materiality, and I showed them why they have to accord substantial dispositive weight to this evidence, okay? So you're going to use headers. I want you to, when you can, talk about and work into your presentation the pillars of arbitration: transparency, predictive value, party autonomy, whenever it is that you can do such a thing. I want you to also understand this thing. Arbitral tribunals, ladies and gentlemen, are not policy tribunals. They are not policy tribunals, but you are more persuasive if you can show that your position is conducive to furthering a good public policy. Adherence to the plain language of contracts is important. Following rules is important. Judging evidence correctly and ascribing weight to your expert witness, whatever it is important. It leads to certainty. It leads to predictability. It leads to transparency, to all the things that are valued in, for example, international arbitration. You keep going, wherever you can, you see that that's relevant, that's very important. Here's something that I want you to please keep in mind. When the tribunal asks a question, I want you to see that as an opportunity, just like when you're asking me a question here. Manuel's asking me a question. No, Manuel's asking me a question. Excellent question, Manuel. Let me address it. The answer is yes, and let me explain why. Okay, so you're going to answer the tribunal's question, point number one, and I prefer for you to answer yes or no and then explain. Okay, because you're going to have a rebuttal. And in your rebuttal, you may want to show that the other side was asked questions and they didn't answer the question. They went on and said some other crazy thing. You're going to say yes, no, and explain. Why are you going to explain? Because in this course, in this chat that we have, we believe, you and I believe, that why things are is much more important than the what, which is just a conclusion. That's why we spend so much time talking about relevance and materiality. Why is more important than what? And it's with that why that you're going to persuade, that you're going to explain, that you're going to break down. So the tribunal asks a question, you say, thank you for the question. You show appreciation for the question. Now, showing appreciation for the question, one thing that is I sit as an arbitrator too. I've sat in exit proceedings and regular arbitration, commercial arbitration. One of the worst things you can do is to appear like a sycophant, like a bootlicker, and to say to the arbitral tribunal, oh, that is a wonderful and intelligent and robust and fulsome question. Thank you. That is a very important question. That is a very relevant question. That question is both relevant and material. Here's why. Yes, and you explain. It's an opportunity. And then when you finish explaining, you say, may I continue? May I continue? You also don't do this, which even seasoned lawyers do all the time. They're arguing their case and they're interrupted. The tribunal asks a question, and then the idiot lawyer says, oh, I'm going to get to that in a minute, and then keeps talking. Oh my God, how insulting and disruptive and disrespectful. The tribunal is everything, and you're looking at them in their eyes and you're focusing on them. Listen to me, look at this for a second. One aspect that I teach associates, a young lawyer, even partners, is the hands. What do I do with the hands? And you see people that the hands are like this, or they're like this, or this. No, the hands open, like you're holding a basketball. Here's an easy way to remember. It's like you're holding a basketball. You're doing everything from this position. There are a number of psychological studies that show, like Manuel now is going like this, like this. There are a number of psychological studies that show that when you're open, when you don't have even this in front, or you want complete communication with that tribunal, you want complete openness, complete connection. So I want that to be your body language, a body language of self-assuredness, security. Okay, another point, this is very important. In your two things, when you are the claimant, you have a very distinct advantage. You have the advantage of being first. And first impressions, they say, are lasting impressions, important impressions, impressions that are not readily dislodged. So you have that advantage. But the respondent has a different advantage, and I want you, respondent, to exploit and explore this advantage, which is your second. You hear everything, and you can incorporate ambiguities, imprecisions, overstatements, exaggerations, and you can comment. The claimant's counsel, this tribunal heard just moments ago, said X, Y, and Z. Now, curiously enough, claimant's counsel can point to no evidence and pointed to no evidence in support of that proposition. And in fact, to the extent that any evidence was referenced, it was neither relevant nor material. And here's why. Now you have relevance and materiality. You know relevance and materiality so well, you know it like you know your last name, and you explain it and you break it down and you talk to you explain it to that tribunal. You see? So I want you to keep that in mind. I want you to work through the elements of the law.
Pedro, apologies. Before you continue, I see there is another question, Francesca.
Good afternoon. I'm Francesca Ulissi. So my question is mainly to the fact that we know that arbitrators are going to press us with question. And because they know the case law and the case file in general better than us, they know what are the strengths and weak points of our pleading. So they, of course, going to ask us questions that are going to hit the most difficult spot. How can we best answer a question that we know we are not in a good position? It's not a strength point. It's something that we are not. It's not something that our client has done correctly, or is something that is not to our favor. How can we answer that still being professional, addressing the question, not avoiding it, but still trying to bring the side, like the tribunal on our side in some way? That is my question. Thank you.
It's a very helpful question. Here's the answer, which may not be to your satisfaction. First of all, before answering your question, I want to say that in your arguments, especially if you're the claimant, I want you to raise the weak points of your case in your opening argument. You raise them. Let me say it again. I want you to raise the points that hurt you, because you will be able to contextualize those points in a way that is most helpful to you. And when those points, you treat those points and you contextualize them, the tribunal doubtless will ask you questions about that. Okay? And now we go into your question. How do I address those questions? But I want you to raise it, because it's important if you raise it. It's important that you take what I call the wind off the sails of the other side. So that when they address the other side, you've poisoned the well. And when they go to the other side, say, well, claimant, counsel, to use that example, already said X, Y, and Z. What is your reaction, Mr. or Miss Respondent, to this argument? And now you have the respondent addressing your arguments, you understand, rather than explaining the strength of its position with respect to your weak argument. Now, here's how you answer the question. You answer the question, first of all, truthfully, but you're going to explain why it appears powerful and compelling, but really it is not. Because when you look at the materiality of that question, and then you get into materiality, you show why really it's not dispositive. It just has a bad thematic, superficial look, but it really is not a foundation on which to make a decision. It has, I'm going to repeat it, it has a bad, superficial, thematic look, but it is really not a propositional foundation on which to make a decision. And here's why. That fact needs to be contextualized and considered with these other 5 different factors. And then you present your case. Look, you have to live with bad facts. The one thing you cannot do with bad facts is ignore bad facts. You have to be the master or the mistress of the bad facts. And you have to persuade that tribunal that whatever inferences or conclusions may be drawn from those facts, those inferences and conclusions are outweighed by blank, your strongest arguments. So the first thing you do is you argue how it's seemingly, apparently, superficially, thematically negative, but how from a substantive proposition, it is not a substantive proposition on which to base the decision. But even if it were, which it is not, such decision always would be outweighed by these other considerations. And that's your case in chief. You see what I'm saying to you? That's the best I can do to help you.
Yes.
So
thank you.
You're going to be in a room, you're going to be in your dorm room or in your classroom or in your house or wherever it is, you're in the library, and you're going to think about this and you're going to develop these arguments. It's when you get to the tribunal, that's not going to be the first time you're going to think about these things. You're going to have this ready. You're going to have this ready, and it'll be a two-pronged approach, a materiality approach and an outweighing of approach by the more favorable considerations, which that's your case. Okay, let me continue. I have a few more things that I wanted to say to you. I want you to use ordinary language. Okay, I don't want you to use 25-cent words. I want you to use simple language and to be direct. Okay. Next point. I don't want you to talk in a monotone. This is not a speech. Listen to me. This is not a speech. This is an argument. What does that mean? That means that there are factual propositions and legal propositions, some of which are more important than other things. If when you're talking to your colleagues, to your friends, to anyone, you don't just talk in this way. You don't just say one thing, it follows the next, because the rules and the order of the universe follows the natural laws of physics and the natural laws of biology. Those natural laws provide some predictive value, although not in every instance. By way of example, we know that all forms of what we have defined as life ends at some point. What is that? That's crazy. Some things are more important. Those more important things you're going to emphasize. You're going to emphasize, like I'm emphasizing now. You're going to repeat them like I'm repeating them now. I want the tribunal to understand X plus Y equals Z. And it must be. And here is why. You see, very simple language, but you see the force of that language? It's its directness, its clarity. Okay, now listen. Another point that I think is critical. Slow down. Slow down. Don't speed through the presentation. Slow down. Don't be monotonous and don't speed through the presentation. Talk to the tribunal. Converse with the tribunal. It is not a speech. Just like this is not a speech. I'm not giving you a speech. This is not a speech. I'm giving you a presentation. And some parts are more important than others. Some parts I really need to get your attention to think about. So please slow down. I want you never to forget in your presentation, in your argument. I just finished saying it's not in your argument, in your presentation. It's not a speech. In your presentation, in your argument, why you are there. You are there because you want relief, damages. Just like you're there because they're not entitled to relief. They're not entitled to damages. You can't award damages to a party that seeks to profit from its own mistakes. And that's what this case is about. This case is about a party who brought an arbitration seeking to profit from its own mistakes, and that is wrong. Okay? So I want you to, depending on where you are, I want you to explain why you're there. Have that, make sure you ask for those damages. You can, one way of structuring them early on, if you're the claimant, of course, is when you say at the very beginning and you alert the tribunal to the different, to the structure of your argument, to the roadmap, to what it is that they are to expect. Now, let me move on to something else very briefly. The witnesses and the witness statements. I want you to tell the tribunal that before this tribunal, there is the testimony of Miss X or the testimony of Mr. Y or the expert testimony of genius Z, and to explain that testimony, in simple language, persuasive language. So I want you to make time somewhere in there to explain the testimony within the structure of your arguments. This is extremely, extremely important. I want you to understand that you're not to use what I call weasel words. I think, maybe, perhaps, virtually, possibly. Forget about those damn words. They don't exist. In our world of argument, everything is certain, definitive, and decisive. Everything is certain, definitive, and decisive. Okay? Now let me go back to the witness statements. Just as you are commenting on your witnesses, ladies and gentlemen, I want you also to comment on the other side's witnesses. Yes, one of the things that you can do here in arguing your case is you present the case, but presenting your case is presenting why your side is credible and why the other side is not credible. So there are going to be elements of those witness statements that are going to be problematic. Let me just start by giving you some easy, low-hanging fruit. A witness statement, and therefore the testimony of a witness, and we're talking about fact witnesses now, need not be based on personal knowledge. Certainly, expert witness testimony is rarely based on personal knowledge. But fact witnesses need not be based on personal knowledge. So you're going to look at the statements that the fact witnesses for the other side, your opposing side, submitted. And you're going to see where it is that they testified to something that's material that is not based on personal knowledge. Now you're saying, but Professor, why are you saying that we're going to see what is based on personal knowledge and what is not based on personal knowledge if you're just finished saying that personal knowledge is not necessary for the testimony of a witness? Right? Isn't that an obvious question? Why are you, did you lose your mind? No, I didn't lose my mind. Here's why it's important. We started off by saying four things: admissibility, relevance, materiality, and weight. Remember that? And we said weight is what we're controlling in opening argument, whether you're claimant or respondent. If you are judging a witness testimony, are you going to give more weight to evidence on personal knowledge or to evidence that is not on personal knowledge, where they heard, where they learned, where they were told, where they conclude, but it's not direct? So you're going to say, so-and-so said X. Of course, that was not on personal knowledge. They did it for whatever, they were told, or they were informed, or they were instructed. You're going to diminish the weight. And you're going to tell tribunal, so you shouldn't give them any weight. Yet the testimony of Mr. X or Madam X on that identical point is on personal knowledge. She saw it, she heard it, she did it, she smelled it, she tasted it, she touched it. Direct knowledge is knowledge that you see through the senses, that you experience firsthand. Let me tell you how severe personal knowledge is. You know that person you call your mother? You know her, right? She raised you, she gave you food, she took care of you when you were sick. Remember, when you were studying, she gave you coffee so you could be up at night and study. That person, you don't have personal knowledge that she's your mother. You don't know directly that she's your mother. You may look like her. Oh, I went to the courthouse and it's registered. Of course she's my mother. No, you read a piece of paper. It's not personal knowledge. Now, your mother certainly does have personal knowledge that she's your mother, that you're her kid. Today, you are in the room you're in, you open the door and you close the door, right, to the room. If I were to ask you now, does the door work? The answer is no, I don't know. It worked when I walked in and out, but I don't have personal knowledge that that same door works now. I have to go and test it. So in a witness statement, how do you know what's on personal knowledge, what isn't on personal knowledge? Well, if the person says, I learned through so-and-so, I saw a piece of paper that said that, I assumed, I concluded, everything that's not personal. Now, if the person says, I saw it, I wrote it, I did it, I was in the room, this is personal direct knowledge. So that's one easy way of saying it, of attacking, of looking at that witness statement, of being critical of that witness statement. Now, here's another thing that's important. Sometimes the witness statement doesn't directly address key issues. So you want to see what key issues the witness did not address, did not consider. And you'll point that out to the tribunal. If you look at that witness X never addressed why. But we addressed why. Here's how we addressed it. Do you see what I'm saying? So you're going to be very critical. Remember what I said, no weasel words, maybe, perhaps, or virtually, possibly, most likely, none of that crap. But when you get the witness statement, you're going to see if they're using those words. It seems, it appears, perhaps, most likely. Again, you're going to have an active intellect. You're going to look at every word and you're going to exploit every word.
Pedro, apologies again. There is a question from Theo.
Yes.
Theo, please.
Yes.
Good afternoon. My name is Stefano, and I wanted to ask you about the time, because as you said at the beginning of your speech, in real arbitral tribunal, international arbitral trials, you have a lot of time, like a couple of hours. Instead, in the moot, we are going to have each 40 minutes. So I wanted to ask you, when you are answered many questions and you still have to address a lot of your case, of your strong arguments, and you do not have time to address them properly because they are just would be too long to do that. How would you say that it is more effective to conclude when you have very few time to address strong arguments and to conclude with strong points? How would you do this?
Look, let's get down to the basics. Thank you for the question. First of all, I want you to write out your argument. Okay? I want you to write out your argument using these rules. And when you write out the argument and you use primacy, in other words, starting strong, ending strong, and I'll talk to you about that in a second. Understanding later how to use rebuttal, but when you have the roadmap, when you have the theme, when you have the recurring theme, when you have the evidence, where you have the critical analysis of opposing evidence, all within a rubric of relevant to the case and material to the outcome, understanding relevance, as I have shared with you, materiality, as I have shared with you, and weight, as I have shared with you, as being the empty thing that we fill with persuasion. You put a couple of propositions. You have your first part, you put a couple of propositions using the advocacy techniques, and then you write it all out, and you see your time. How much does this give me when I speak slowly? It is not a speech. It is an argument. You're proving your case. When you're proving your case and you write it all out, you time yourself. Now, the trick is not the trick, because there are no tricks here. This is not a magic show. But the preferred approach and methodology is to, again, have an understanding of the importance of each argument and starting with the important in that order. And there are going to be things that you're going to have to leave out. There are going to be things you're going to have to leave out. And perhaps one way of leaving those things, when you have to leave those things out, you're going to have that written down in another piece of paper. And depending on the question, you may be able to bring those issues in, depending on the question from the tribunal. Sometimes some of these issues you will explain in 1 or 2 sentences, and that's it. You could just say the main propositions contained in Mr. X's witness statement are interesting, they're relevant, and they're material in this regard, but they are not based even on personal knowledge. Not that they have to be, but the tribunal should take this into account. By way of contrast, Ms. Y's personal testimony on this identical point is based on personal knowledge and therefore more credible and therefore should be accorded greater weight. So you're gonna, the time issue, you will have, you have this approach. Then you have a partner in this. You're not alone there. You're not sitting there by yourself. Your partner is charged with keeping time, okay? And your partner is going to tell you when you're 50% through, okay? When the first 20 minutes are up. The partner is going to tell you when the last 5 minutes started. And the partner is going to tell you when you have 2 minutes. When you have 2 minutes left at that point, you turn to the tribunal. And if you're on target, if you're pacing yourself well, you have nothing to do. You go, okay, I had 2 minutes, and that's more or less accurate with what you're saying to yourself. That's more or less accurate where, you know, where I thought I was going to be. You keep going. If not, you turn to the tribunal and you say, respectfully, members of the tribunal, because of the time constraints, I am going to focus on argument X for the remainder of my time. And then you go and you close nicely. Now, let me go back to 2 things. I spoke to you about answering the questions. Remember from the tribunal? One of the techniques that I really like a lot, either in answering the questions or during your presentation, is to raise questions that you want the tribunal to ask the other side. In other words, you answer the question and you say, and indeed, we look forward to hearing how respondent or claimant or whoever will address this very question, X, Y, and Z, and we encourage the tribunal to pose it. The tribunal then writes it down. And again, as I said, when the other side comes up, the other side's ready, they have their arguments ready, and they're thrown off completely because the tribunal says, before we start, opposing counsel said this, and I want to hear from you on it. And the person's going, oh, shit. Now I've got to answer this. I'm all confused now. I've got to get my act together. You understand? I'm in trouble. You see what I'm saying? So that's something that I want you to do. You can do it in the argument or you can do it in the question format. Now, rebuttal. Listen to me. Listen to this. Guys, the tribunal is tired. The tribunal is hungry. The tribunal is human. And therefore, the tribunal is easily distracted. The tribunal falls asleep. The tribunal thinks about bills that should have been paid that weren't paid. The tribunal is wondering if they can catch a plane out of this in time or stay an extra day or check out later in the hotel or where can I get some pizza around here? You understand? The tribunal is with all sorts of things. You want the tribunal to be 100% focused, okay? So when you end, you're going to end with a strong ending. You're going to anchor your arguments. You're going to anchor your arguments after every heading, okay? And then at the end of the whole thing, you're going to have a conclusion. It's going to be a 3-sentence conclusion, no more. If you can do it in 2, that's even better. And then you're going to bring out that conclusion. You're going to, therefore, it is conceptually impossible for X to have been the case. Because it is conceptually impossible, as a matter of evidence before this tribunal, for X to be the case, we respectfully invite this tribunal to consider ruling in favor of claimant. We respectfully ask this tribunal to consider respectfully ruling in favor of respondent. Invite to consider, ladies and gentlemen. You do not tell the damn tribunal what to do. No one does. Okay? You are polite in this way. This gives you credibility. This does not place you in a confrontational position with the tribunal. Which leads me to my next point. Please, please, whatever you do, do not argue with the tribunal. Do not argue with the tribunal. Too often, the lawyers, people who get paid to do this. And I'm sitting there, I'm going, oh, this is great. This idiot is arguing with the tribunal. Oh, let me just sit down and keep hearing this. You understand? So I wanted to share these thoughts with you. These are just thoughts. This is just an approach. We're very limited, of course, in time and the ability to really get into this deeply. But I really hope that this session has helped you and that it will help you prepare your arguments. And I can tell from your questions that you're very invested in what you're doing and that you're going to be extremely successful, not just in the Vis Moot, but in life. And that's what really matters. So I want to thank you for your questions and your patience.
Thank you very much, Pedro. An applause for Pedro also virtually. Here in this context, we can say virtually, but not in the pleading. And are there last questions from the audience? You have the great opportunity to speak with Pedro.
I had a
Please.
question just out of curiosity, actually. In your experience, like how often is a party exempted from liability for damages based, for example, of force majeure clause or other provision on exemption? Like how often in reality does it happen?
Oh, it happens a lot. It happens, but it has to be established.
Okay. Because
It has to be proven.
in our case, we are applying the CSG, and Article 79 is very strict on the prerequisite in order to be exempted. But there's also in the contract a force majeure clause, with it's more broader in the interpretation. So we're trying to argue that this clause does not apply. It applies Article 75 because, of course, I'm arguing that I am entitled to damages. I'm claimant right now.
Course.
So
Yes. Yeah. I mean, the article, the tension that you have here from just that sentence you said is a tension between, again, the written word of the which works both ways, the written word of the contract and an applicable legal stricture, and which one should prevail. And it depends, of course, on which side you're arguing. You're saying the reality is that by applying, Article 79 or whatever it is, you're really applying the will and the meeting of the minds of the parties, because the parties contemplated that this would apply. The other side has the identical argument, but with respect to the sanctity of a contract and why the parties explicitly put that language there, because they wanted that language to be in derogation of this article. And to just merely use the law to rewrite the intent of the parties is a misapprehension of equity, justice, and fundamental contract law. So you see, both arguments are very nice. They're mirror arguments, obviously, written with a lot of bad faith, so you can have a good show. But anyway, I want to wish you a lot of luck. You guys are you're gonna do great, and I hope this helps. If you ever have any questions, you can send me an email. And also, by the way, join my YouTube channel and join me in LinkedIn, subscribe and hit like.
Okay. Pedro, do you have a couple of minutes still, or you have to leave?
Sure, yes, I do,
Okay,
yeah.
so final questions, Manuel?
Yes, Mr. Pedro. So do you think it's better to conduct our pleading by using the first person, the third person? So for instance, by saying this council submits, or I submits, or we submits. So what do you prefer?
I prefer the lawyers to stay out of first person or third person. I want you to talk in terms of the client. And I don't want you to call the client claimant or respondent. I want you to call the client by its name. Even if it's a company, I prefer for you to humanize, to have particularity and to stay away from generics. The I, the me, that is distracting. You want to be one with that client. You understand?
First. Thank you.
What I wanted to say before, by the way, was about the rebuttal. In the rebuttal, I don't want you to repeat things. Don't repeat your arguments and rebuttal. Rebuttal, just pick up 2-3 points that are weak in what the other party said and what the opposing party said, and then exploit those so that you can challenge their credibility and you can challenge the merits. Okay? That's what I want you to do, rebuttal. Rebuttal should be short, but succinct and devastating. I just want to bring to the tribunal's attention 3 points. Number one, X, Y, and Z. That just simply cannot be the case for this reason. Second point, A, B, and C. That is completely false or untenable, inviolable for these reasons. And then finally, third, You understand? And then before you sit down, we claimant or respondent encourages the tribunal to ask a claimant or respondent on the other side question A, B, or C related to what you've just said, and you close it up. Okay?
Thanks, Pedro. And very last question, Francesca.
Yes, my question was exactly on the rebuttal. Usually, in your experience, what is the best time, like time management, to give a rebuttal? 1 minute? Too much? 30 seconds? 45 seconds?
Very little. 1 minute, a minute and a half, very little. In my opinion, the point of the rebuttal, in fact, sometimes you don't even use a rebuttal. I'm not saying the Vis culture. In the Vis culture, you probably have to. But the point of the rebuttal is to show a decisive flaw in the opposing party's argument, or two flaws, and to maximize that impact, and then to tie it up so that leave them with a question to ask the other side, so that you can engage in the misdirection technique that we just described earlier.
Thank you.
Okay, guys, listen, good luck. If you have any questions, email me, and please join my YouTube channel and follow me on LinkedIn. Goodbye, Professor.
Pedro, thank you very much. Last second for the screenshot picture for our socials, if you do agree, Pedro. And
I agree.
we will tag you on LinkedIn as well.
Super.
Who's taking the picture from the Moody's?
I am taking the picture.
Okay.
Okay.
Thank
Rock
you.
and roll.
Okay, great.
Okay, guys. Goodbye. Have a great weekend, okay?
Thank you.
Thank you, Pedro.
You too.
Bye-bye.
Go get them.
Thank you
Go
so
get them. Bye.
Bye. Thank you.
Mi sentite?
Sì.
Sì, professore.
Allora, stavo un attimo. Dio. Poi dobbiamo Ecco qua.